I just want to remind you that tonight's program is going to be recorded, so that if you are asking questions about trusts or your personal situation, I just want to remind you that, so you can be mindful about how much you want to share, because it will be recorded. You do have a copy of the presentation. We emailed it earlier today, but again, it will be recorded and you'll get a link to the recording later after the presentation. I don't have to tell you where the bathrooms are. You all know where they are. And let's see. A disclaimer: tonight's presentation is for educational purposes only. You know, legacy planning, tonight we're talking about a legal topic, but legacy planning also involves tax and financial planning. We don't endorse any particular professional advisors, but we definitely encourage you to consult qualified lawyers, tax advisors, or other professionals. State funding for legacy planning work in these webinars in Vermont is provided by a VHCB Farm and Forest Viability Grant. And also we have a special sponsor, Kings Point Capital Management, and we'll have a word from them now.
Today's program is brought to you by Kings Point Capital Management, proud sponsor of the Vermont Woodlands Association. Kings Point Capital Management is a registered investment advisory firm that was founded by a team of Goldman Sachs executives, including the former director.
Did that stop playing?
Yes.
Nope.
I wonder if that's your internet, Mary.
Oh, here it goes again.
Research, Jack Salzman. The firm has offices located in New York and Tennessee and clients throughout the globe. Kings Point Capital Management provides highly customized investment management services for high net worth families and foundations. Their clients often have complex wealth scenarios involving unique investment objectives, numerous investment accounts, and varied family entities. The experienced team at KPCM brings decades of investment experience in managing family wealth and advising on generational wealth transfer needs. Kings Point Capital is dedicated to achieving your family's financial goals, working collaboratively with your accountants and attorneys, and delivering an unparalleled level of service. Feel free to contact Jake Marshall at KPCM for a complimentary financial analysis or with any questions.
So with that, I will turn it over to Sarah. Let me stop sharing so Sarah can start sharing.
Okay. Thank you very much, Mary and Kathleen and Kings Point, and to each of you for being here tonight. My name is Sarah Tischler. I am an attorney at Langrock, Sperry & Wool, with other estate planning attorneys who, like me, I think we're more nerds than we like to think we are, but we kind of like this stuff, even if it's death and taxes and annoying legalese language, but we try to make things simple. Just a little bit about my background. I grew up in Vermont. I was pretty much a feral child running around in the woods and the fields, and ended up going to college and majoring in environmental and ecology sciences. Went off to law school thinking I'd be doing environmental law, and ended up in estate planning, which actually has circled nicely back to land conservation and succession planning for woodlands. It's been a treat to work with Mary and Kathleen over the years on topics near and dear to my heart, keeping our lands healthy and preserved and helping families figure out how to do that. So I am talking about trusts this evening, the basics. We're going to focus on the revocable living trust and compare that to a will. Talk about probate. There are a lot of myths out there about how trusts and wills work. So we'll take a peek at that. We'll look at how you'd make a living trust work for your own benefit, for efficiency. We'll take a break, we'll take a pause a little bit along the way just to make sure that there aren't any questions and folks aren't stumbling around too much in the woods. Try to keep the picture of the forest, but I'm pleased to be here this evening, and hopefully I'm going to be able to share my screen and you'll be able to see my presentation. So let me do that. So one participant can share at a time. I'm going to share my screen, my PowerPoint, and everybody should be able to see the title page, Trusts, What, Why, and How.
We don't have it yet, Sarah.
You don't have it.
No.
Let
So did
me
you,
go back and see if I've shared my screen?
down at the bottom, the green share screen?
Yeah.
Yeah.
Oh, it says it's asking me for the
There
blue
we go.
to share. Okay. And there we go.
Great.
And a slideshow. How's that?
Perfect. Thank you.
Okay, great. So yeah, let's just wander in through a forest of legalese, and we hopefully won't get lost. You're looking at not a healthy forest. We'll end up with a healthy one at the end. And we will see the forest for the trees. What is a trust? Lots of people over time were pretty convinced that trusts were just a way to lock up assets, particularly for daughters who couldn't inherit money, so their money got locked up in a trust. But society has changed over time. It's been interesting to see that evolve. And now trusts are really a very common tool used to take what you have and get it to others very efficiently. A trust itself is just a set of written directions. Those directions are ones that you get to write up. They reflect your wishes for what you want to have happen with assets in the trust. You name a trustee to follow those directions. You can title assets in the name of the trust. So basically the trust becomes the owner of the assets, the title holder, and your directions guide your trustee in managing, using, and distributing the trust assets for people, pets, charities, whoever you've named in your trust agreement. Those are the beneficiaries. So there's sort of three corners to every trust. One is the person setting up the trust. That person can or cannot maybe retain control over the trust depending on the style. So there's the person creating the trust, the trustee named to follow the directions in the trust, and the beneficiaries, who are the people named who will have the benefit of the assets in the trust. I mentioned revocable trusts or irrevocable trusts, or revocable or irrevocable, depending on which emphasis you want to put on which syllable. But revocable and irrevocable are both established during your lifetime. You want to create the trust agreement with the directions that you want. In a revocable trust, those directions can be changed. And if you're the one that created the trust, you get to change those directions. So also in a revocable trust, the person who's created the trust is usually their own trustee. So you are actually not really giving anything away to anybody else. You are creating a trust to hold title to assets that you want to have continued control over with a revocable trust. And it's usually used, a revocable trust is usually used to avoid probate court involvement upon capacity or death. And the irrevocable trust, obviously the difference is that the directions cannot be changed once the trust is signed. The person who's creating the trust usually is not the trustee, because the goal is to shift the assets out of the person's own estate, usually for a tax strategy, some kind of estate planning strategy. This is alphabet soup. There are many, many styles of trust out there, and some of them are pretty absurd. Named. But you may have heard some of these titles, credit shelter trust or marital trust. Just a comment, I think somebody might not be muted. There's some background noise. If everybody could check, that would be great. So there are trusts and Q-tip trusts and charitable trust and intentionally defeated trust, and the list could go on and on and on. Revocable and irrevocable trust can come in many, many different styles. Again, the trust that we're going to focus on tonight is the revocable living trust, the one that is often used as the keystone in somebody's estate plan. And just as an aside, when I talk about estates and estate planning, in my view, an estate is everything that you own and care about and the people that you care about. So you may think, oh, I don't have an estate because I don't have a pillared gated driveway, a mansion. But pretty much any person has something that they care about, that they want to make sure their directions for. So when I'm talking about estate planning and estates and assets, it's basically anything that you want to make sure you've got some directions. So in an estate plan, there are commonly things like wills, powers of attorney for financial matters and healthcare decision-making, and this revocable living trust. So just to go back through some of the key concepts, this living trust is something that you create, and depending on the custom and practice of the attorney you're working with on setting up the trust, you might be called the grantor or the settlor or the donor or the trustor. But those are all names for the same thing, which is the person who's creating the trust and developing the directions. Usually with a revocable living trust, you're going to name yourself as your own trustee. You'll name people to step in as successor trustees if you can't serve. But again, that's your choice. You control completely any assets titled, owned in the name of the trust. And the trust agreement will have typically 3 parts to it. One part in the trust directions will say, okay, I'm living, I'm competent, the assets are all mine, I get to use them for whatever I want, and I can change this at any time. So that's part 1, you're alive, you're competent, and it's all yours. If you become incapacitated, the second part of the trust would say, okay, I can't make decisions anymore myself, I can't manage my assets in the trust, So the successor trustee, the person you've named to step in and take care of the assets, is then going to step in and follow the directions that say all these assets are still yours and need to be used for your benefit. So you have that covered as well. In the absence of a trust, let's just talk a little bit about incapacity. If you're not able to manage your own assets, you either need a trust that's holding your assets and a successor trustee, or you need a power of attorney for financial matters. Power of attorneys are documents where you appoint somebody to act on your behalf when you can't. Very, very important documents. If you don't have either a trust or a power of attorney, then someone is going to have to go to the court, to the probate court, to get a guardian appointed to take care of your assets. So incapacity is a big piece of the value of a trust, as is a financial power of attorney. But with the living trust, you get directions in that document that say these assets are to be used for you, and you've named your trustee, and the trustee has immediate access to the assets and can manage them for you while you're incapacitated. So that's the second part of a living trust. And the third part of a living trust is what happens at your death. And again, who is the trustee that's going to step in to be in charge? And with a living trust, because you've already titled your assets in the name of the trustee has immediate access and authority to follow the directions for the assets and can take care of the assets and implement your wishes immediately. So that's a general overview of the living trust. It's always in your control. It's always your own asset until you die. And then it's irrevocable, but your directions are the ones that you've put in there. I want to compare living trusts with wills. Many people are much more familiar with wills than they are with trusts. And in some ways, wills are very similar to a living trust. Both of these tools set out directions for who gets what when you die and who's going to be in charge to make sure that all that happens. The directions you have in a will or a trust can be changed at any time during your lifetime. That's your right. Those documents don't have, just because you've named a successor trustee in a trust doesn't mean you lose control of your trust. As long as you're the creator of the trust, it's always yours. You can change it at any time. You retain complete control over the directions and your assets, and both documents become irrevocable upon death. No one can change your directions that you've made once you've died. Those documents become irrevocable. So how is a trust different than a will? And in some ways, they're very, very different. The living trust springs to life once you sign it. It's effective during your life, and as we just discussed, through incapacity and after your death. It's really, I call it a living, working tool for how you want to own your assets, because the living trust can actually become a title holder of real estate or a bank account, investment account. It is an important choice that you have in terms of how to make sure your assets go where you want. We're going to talk in a little, once we've covered the will and the probate piece, we will talk about how you use a trust to own title to your assets and the choices that you have, things like beneficiary designations versus titling assets in the name of the trust. But the important and the huge difference between living trusts and wills is that assets owned in the name of the living trust are not subject to probate court process upon incapacity or death. Wills govern only assets that are subject to probate. And I do want to talk a little bit about probate. I'm just going to check the time. It might be a good time to just make sure that people are on the same page with me. Kathleen, are there any questions that we should talk about?
There was one question I put in here earlier, Sarah,
Okay.
about beneficiary designations.
Yep.
Is that something you're going to cover?
Yep, I will get to that. Yeah.
Okay. So I don't see other questions yet, and maybe we didn't mention, folks, that you can put your questions in the chat box and I will make sure that Sarah gets those. So
Okay.
that would be a great time if you have any so far.
Okay. Great. Well, I'll keep plugging along then.
Okay.
So lots of people think wills keep you out of probate. And I was having a conversation with clients that I worked with for about 20 years on their estate plan, who asked me again about how come if their wills say their daughter gets Blackacre, that's the anonymous land hold that we all lawyers love. If their daughter gets Blackacre and it says it in their will, why does it have to go to probate? And even though I do try to explain things like this over and over in Estate Planning 101 for my clients, it's just a really common myth out there. So I get the question, what? My will is subject to probate? And some people will say, well, I'll be dead, so I don't care. It's not going to bother me. But most folks don't feel that way. And I've found that they want to know why. Why? What is probate? And why do I care? And let me give you just an overview of the probate process, why it's important and essential, but it's driven by how you own your assets. And again, when I'm talking about assets, I'm talking about everything from your real estate, your life insurance, your bank accounts, your things in your home. So when I'm using the term assets, I'm not talking about any particular type. I'm talking about anything that you might own. So what is probate? It's a detailed process. It's governed by state law. Vermont statute is quite detailed in terms of what the probate court oversees. The probate process can take a lot of time. It's a public process. The beneficiaries all get to participate. They get to say whether they think the will is valid or not. There's detailed reporting that has to happen to the court on assets and income and expenses that are paid from start to finish, and it can be expensive. The purpose, though, of the probate process is to make sure that the right person is given the right authority to access and distribute assets that get stuck upon someone's death. And assets that get stuck upon someone's death are assets that don't have any other instructions attached to them. So not all assets are subject to probate, but here's an example of a probate asset. You own a bank account in your own name, just your name, period. No joint owner, no beneficiary designation. It's not in the name of a trust. It's just your name alone. And you die. Your bank is sitting there asking, okay, who has the authority to access this account? Who is supposed to inherit the account? The bank is not going to hand this account over to just anybody. there's got to be some form of official documentation before it will allow access to the account. And that official documentation comes in the form of the probate court's appointment of the executor named in the will. In order to get your executor named and appointed by the court, the will has to be filed with the court. Everybody named in your will has to give written approval that the will is valid. The court approves the will and then will issue a nice certificate of appointment, a nice gold seal that your executor then can take to the bank to access your account. And that's just the first step in the probate process. So assets that are not subject to probate and can be accessed immediately are assets that have instructions attached to them. One really common form of ownership, one of the choices you have when you look at what you have, look at the assets you have and you say, okay, how can I own this asset? Joint ownership with rights of survivorship is a very common tool. When you have that designation, JTWROS, and you own an asset jointly with somebody else, ownership transfers immediately and instantly to the surviving joint owner on your death. Tenants by the entirety is a way to own assets between spouses, between a married couple. It gives some asset protection to those assets owned as T by E, tenants by the entirety. Its function is the same as joint ownership. It's 100% immediate instant transfer to the surviving joint owner. So investment accounts, bank accounts can all be owned with rights of survivorship. You can have jointly owned real estate as survivorship titling. Lots of people don't realize that a tenancy in common, though, is individual ownership. So real estate sometimes people say, well, I own it jointly with my siblings, but in fact, the siblings might all have a separate tenancy in common interest. So that's joint ownership in a way, but for estate purposes, what's going to happen to that tenants in common interest on death, that's going to be something that's in your sole name and will go through probate. It won't pass automatically to the surviving siblings. So anytime anybody has real estate jointly owned with another person, we always look at the deed to see what is the actual ownership structure. And tenancy in common, we would normally say, well, let's change that to joint ownership with rights of survivorship, or have the tenancy in common interest owned in the name of the person's revocable trust. So that's just a real estate piece that often trips people up, and I wanted to point that out. Assets with beneficiary designations that name people or trusts. Those assets are not subject to probate because there is a set of instructions attached to the asset, and those instructions are on record with the financial institution. So you may see things like TOD, transfer on death designation, or POD, payable on death, or ITF, in trust for designations on bank accounts or investment accounts. Those are just like beneficiary designations on life insurance or retirement accounts. There's no probate involved. Your will does not govern assets that have beneficiary designations. There's no need to go to the court to say, okay, who's supposed to get this? That designation is already in place. So it's hugely important to make sure that beneficiary designations are up to date. And then assets titled in a living trust are not subject to probate because the trust agreement itself has all of the directions that are needed for your successor trustee to step in and deal with the assets titled in the living trust. We often talk about funding a living trust. Funding a living trust is the process of coordinating the ownership of your assets with the trust so that the trust actually governs your assets. So a trust only governs the assets that are either titled in the trust or are going to pass to the trust on death by way of a beneficiary designation. So it is a choice. You have a choice when you think if you've got a living trust in place, you have a choice of what assets you actually title in the name of the trust. Let's say you want to change the ownership of an account or real estate to the name of your living trust. You've created the trust, you've named yourself as trustee, you've got all your directions in place, you've done that part. Now, this next critical step of actually attaching the trust directions to the asset is a critical one. The new owner, the title holder, would be designated something like this: Jane Doe, trustee of the Jane Doe Living Trust, dated November 10th, 2020. Or whatever the date is. The date that you sign your trust agreement becomes part of the critical piece of identifying the trust. So that's sort of the full and complete expression of how your bank account title or your investment account or your real estate title might look if you were going to actually take an asset and change the ownership to the trust. Because you retain control over the trust, you haven't given anything away. The tax reporting number is still going to be your own Social Security number. You own assets in the name of the trust for all purposes, just as if you owned it individually. You've just given this set of instructions that makes it possible for that asset to be governed by the trust and transferred as easily as possible to your next in line. There's no separate tax reporting during life with a revocable living trust. It's still your Social Security number. The difference is that the ownership in the name of the trust is in the records of the bank or the financial institution or the land records. Wherever the asset is on record, then you've attached these governing instructions to the asset so that on your death, when there's a change or incapacity, when there's a change of who's going to be the trustee, everything that's needed in order for your successors to step in and take care of your stuff is all in place. So there's no need to go to the probate court. There's no other authority needed. So I would just again note that you sign the trust agreement, but it's not enough just to sign the trust agreement. You have to make deliberate choices about and deliberate communications with the institutions for the assets that are going to be changed to ownership in the trust. Another common way to fund a trust is to name the trust as the beneficiary, particularly of life insurance or maybe a bank account. The designation, when you're funding a living trust, to name the trust as a beneficiary, is something like the trustees then serving of the Jane Doe Living Trust. Because usually a beneficiary designation becomes effective on your death. So we don't really know who might be serving. We know who you've named in the trust agreement as your successor trustee, but usually we'd name a first, a second, and a third trustee, successor trustee, just in case the first one isn't able to serve, we name the second one. So I try to leave it open when you're filling out a designation for a life insurance policy, that the trustee is going to be the one, whoever's serving at the time. You know who you've named, but we don't know actually who might actually be serving. The nice thing about using a beneficiary designation is that you remain the owner of the asset in your individual name. But again, you've attached a set of instructions to the asset. It's important and essential, really, to obtain the forms to update or designate a beneficiary from the custodian of the asset. So if you want to add a transfer on death or a payable on death designation to a bank or investment account, you have to go to the bank to do that. If you want to name a beneficiary on your life insurance, you have to get that form from the insurance company. Same with retirement accounts. It is not enough to sign the trust agreement and say, I want everything governed by the trust. You actually have to be very deliberate in making sure that you do this funding process. Just a quick word on retirement accounts and in relation to the question that came in earlier. The question was, does everything have to go in a living trust, or can you still have assets going directly to people? And retirement accounts are one of the first things that come to mind with that question. Retirement accounts usually have some built-up income tax liability. They're pre-tax dollars, unless it's a Roth IRA. For income tax purposes, it's usually always better to have retirement accounts being designated to people as opposed to your trust. You can use a trust to receive retirement accounts. There's special language that's really required to make sure that that can all happen smoothly and without a bad income tax consequence. Without the special language, a retirement account payable to a trust, there's a high likelihood that the account will become immediately subject to income tax, the entire account, as if it were withdrawn by you during your lifetime. So retirement accounts, generally we encourage people to name people directly or charities or combination. Charities can take retirement accounts without paying any income tax on those monies. So it's a nice way to support charity. You can name beneficiaries on all of your assets and not use a trust. The big disadvantage there is that if you've named your assets to go directly to people and there are expenses or taxes due upon your death and you haven't got a fund, a receptacle for at least some of your assets, there's a possibility that somebody's going to have to go chase after siblings or children that don't get along and say, hey, everybody's got to pony up to pay some of this. So that can be a little tricky. Usually, again, it's just a deliberate process. What makes sense to have in the trust and what makes sense to go directly to people? It's going to depend completely on your personal circumstances. But usually you want to make sure that there's some kind of estate bucket, trust bucket that's going to have some cash to pay expenses, get that all taken care of, and then distribute the rest. Perhaps you've got a trust that has special directions for the long-term management of either a child's inheritance or your real estate, your woodlands. That's going to be a choice where we say, okay, we're going to want to make sure that the trust truly governs that asset. And so funding the living trust with a deliberate process of looking at each and every asset and saying, okay, what makes sense for that asset is the process that you would go through if you were to set up a living trust. So what directions can I include in my living trust? Anything you want in terms of what you care about. These happen to be my guinea hens, and I care about them. I don't have directions about my guinea hens in my living trust, but I could set aside money to take care of my guinea hens if anybody wants all the noise. But really, again, back to what it means for your estate. what I consider your cherished assets. The directions you include in your living trust should reflect what you want to have happen with the things that you care about, that you've stewarded, either distributing them directly to family members or charity or whomever, or holding them in more of a long-term structure so that there's management over time by designated trustees. In the chat room, I've included for your review, your reading pleasure, a sample of trust provisions that were written for the long-term management of a family woodlot. It's one set of instructions among many that are out there. I want to emphasize it's truly one sample, because there are many ways that people set up trusts to manage woodlands over time for family members. This is one example of that. But again, your trust, just like a will, should reflect your wishes. And so in thinking about what you want to say, really it's going to be driven by your personal goals. And what I try to encourage folks to think about is just that. What are your personal goals? Because if you can articulate those, or you worked with your family to articulate those, and then you meet with the lawyer, you can go, you can be much more efficient, and the lawyer can incorporate those instructions in a document that really speaks to your family and is efficient for your family and can address contingencies. What you care about and what your goals are the most important things, I think, for you to think about when you're thinking about your estate plan as a whole. If you end up using a trust, great. Not everybody uses a trust. I've also included here in those additional materials an informational sheet that we give to clients just on sort of typical steps about coordinating assets with a living trust. There are common things to do and easy things to do, and then other things to think about, again, like retirement assets might not be the right assets to coordinate with the trust. Really depends on your personal circumstances. So I'm going to stop there and show you a different picture of a forest that I know is managed. We want to stay safe and stay out in the woods, and thank you again for your interest in all this, and certainly ready to take more questions as they might come right now. I know we are going till 8. We have about 11 more minutes. So I'm happy to hear questions and go from there.
So Sarah, there is one question here. We did not talk about LLCs tonight. And Mary, can you confirm if we are going to talk about LLCs in the future?
We are going to talk about LLCs on the second Tuesday of next month. So the second Tuesday of December will be our last legacy planning webinar for the Woodland Legacy Planning series, and it will be all about LLCs.
Okay. Is there a simple answer to this question? What are the relative strengths and weaknesses of trusts versus LLCs for stewarding family forests?
That is a very good question, and I have used both. We, in our practice, it's driven somewhat by the amount of control that someone would like to exercise over the future of the woodlands. An LLC, I'll try to be really brief. An LLC is a corporate form of entity which the members, the stockholders, basically that concept the stockholders will have control over, and they can create a management plan and arrangements that make sense for them. With a trust, by comparison, the person setting up the trust is the one who lays out a lot of the ground rules sort of for the long-term management of the property. And in some ways, a trust can feel more like a legacy, a gift, because the individuals don't become owners of the real estate. The trust remains the owner for the benefit of those individuals, so for the benefit of the family. And in some ways, there's a sense of enjoyment and use and benefit, but not, oh, I have an asset that I can sell. And that would be true with an LLC. You get a membership interest in the LLC that is yours. So mom and dad die, the real estate's in an LLC, the kids inherit the membership interest in the LLC, and they have an asset that is part of their marital estate or their creditor's claim or estate taxes. It's part of what they own. And the siblings can change the directions for the LLC if they all agree. With a trust, you don't get that individual ownership. You have the benefit and use of the real estate. And usually there aren't buyout provisions. Usually the future beneficiaries of the trust will be the next in line in terms of descendants. So it's not something that the beneficiaries have control over in the same way that it's an asset that becomes subject to division on divorce or a creditor's claim or included in the beneficiary's estate for estate taxes. I'm going to stop with that. Again, sort of a personal preference from the family, what kind of ownership and control is desired. And that's probably those are the biggest differences. I'm going to stop sharing, although I like the picture, but come back into view. Any other questions?
Sarah, I just tried to use the chat box, but I couldn't, so I'm going to ask my question this way. How long does a trust last? For how long does it govern, your trust directions govern what happens?
Yeah, that's a good question. Oh, and it's got a classic lawyer's answer. It depends. So a trust can last for only until the assets are distributed, if that's the directions. You can say, well, on my death, I want everything divided equally among my children and my niece, and that's the end of it. If you set up a trust that continues over time, then you can say how long you want it to last. So there are limits under state law for how long a trust can last. It can last as long as the rule against perpetuities allows it to last, which is 21 years after the last person who was living when the trust was created. So it could be multiple generations. But often, yeah, it's going to be driven by the personal preference up to certain limits that might be in state law. I do have some people who will say, you know what, I want to give the family 10 years. I want them to have 10 years to decide what to do with this property. And I'm gonna say in my trust, here's a bunch of money that's gonna pay for the real estate taxes and the forestry management plan and current, all whatever else might be associated with maintaining the real estate. So you've endowed the real estate with a bucket of money that will make it possible for the next in line, the next generation, to figure out what they want to do. And they'll have some time to see what's the reality here. What does it really mean to keep these acres, and to have somebody have to be there to manage it, or the family camp that's located on there, and what does it really mean to us to have this? So you have choices all along the way.
Thank you.
Thank you.
Yep, and folks, feel free to ask those questions if you're having trouble with the chat room as well, if you have any. So let me ask Sarah, just for clarification. Let's say I want to establish a trust. I own property, I own my home, I want to put those both in the trust. Do I need to deed those assets to the trust in order to put them in the trust?
Yes, so that would be one set of the instructions that are going to go into the land record, so that everybody knows who has the authority to transfer ownership of the real estate, or who is the owner for tax purposes, for real estate tax purposes, or current use. If land is in current use, there would be both a deed to the trust and then a transfer application for current use to make sure that the trust is the named owner. But yes, a deed would be the proper way to transfer real estate into the name of a trust.
And if any of those assets are mortgaged, does the trust then have to be the mortgage payer? I mean, do you have to re-mortgage to put a mortgaged property in a trust?
If you were transferring mortgaged property to an irrevocable trust and actually giving the property away out of your own hands, then you'd have to do something with the mortgage. But fortunately, there's both federal and state law that says a transfer to a living trust, a revocable living trust, is not a default. It's not a cause to call the mortgage. That used to not be true. We used to have to get permission from the banks, and some of the banks charged like $300 to give their permission to transfer the property to a living trust. Fortunately, we don't have to do that anymore. So that's a good thing. When you do transfer real estate, is the first one that comes to mind, but when you transfer real estate to a living trust, you do also want to make sure you've notified your insurance coverage so that the trust can be an additional insured in the policy, because it is a change in title. Even though you still own it, you don't want there to be any question on the insurance end if there's a loss and you need to make it. And they check that.
Thank you.
Yeah. I'll offer just one other thing too about living trusts and compared to wills. I mentioned that the probate process is a public one. So your estate, whatever is going through probate, anybody who wants to can go down to the probate court and take a peek and say, what's going on here with Jane's estate. A living trust is a private document. There's no court involvement. So it is a way to avoid that public process. When people are funding their trusts, and let's say they want to change the ownership of an asset, of an account to the trust, sometimes the institutions will say, well, we need to see a copy of the trust. And my answer is always, no, you don't need to see a full copy of the trust. I'll show you the first page and the signature page and the powers or we'll do a trust certification saying, here's what you need to know about the trust, but you do not have to share your personal wishes with the institution. It's getting a little harder to do that because of the Patriot Act and everybody's so concerned about foreign monies and that sort of thing. But generally, when you have a trust and you're changing the ownership, you do not have any obligation to turn over the entire trust agreement and share your personal wishes, not the business of the bank. But that is one reason why lots of people will go to a beneficiary designation, the payable on death or transfer on death designation, instead of changing the actual ownership to the name of a trust, because the beneficiary designation is, the bank is much less likely to need to even ask to see a copy of the trust with the beneficiary designation. So that's sometimes it can be a lot easier to use the beneficiary designation.
Thank you. Sarah, is your email on the PowerPoint?
My email is not. The Langrock website is.
Okay.
So, and you can email any one of us in the estate planning group. They all know that I'm doing this presentation.
Okay.
All consented to have me do this presentation.
One of the things that you and I talked about earlier today was how to identify an attorney. I know you had a list of questions that maybe we could share with folks who were here tonight.
Absolutely. I will email that to you.
Okay.
And just to explain it to the folks online, it's a set of questions that is just, how do you know if you are working with an attorney that actually has experience in estate planning? There are many wonderful, wonderful attorneys out there. And they might prepare wills, but just preparing wills as a sideline is not a very good substitute for a true and comprehensive estate plan. I don't do real estate and I don't do litigation. Absolutely not. You would not want me to do those things. But I think there are many great estate planners around the state, and the questions are really designed to help you figure out if they actually do estate planning as a primary part of their practice, so that they'll be able to really make sure that things are exactly the way you want them to be.
Thank you. And I will forward that to everyone, that document, when Sarah shares it with me.
Happy to do that.
Good, thank you. We are at 8 o'clock, actually 8:02. And so if there are no other questions, we are probably going to say good night. And if you do have questions that you did not ask tonight, please send them along to me or send them to someone. You can't use Sarah and her firm as your attorney, but if there are simple questions we can answer to help you take the next step, we could probably get those answered for you.
Yeah, and thank you to everybody for your interest, and hopefully you'll find a great way to get a good plan in place, and I encourage you to do that. So you work too hard and care too much about things that are important to you.
Double down on that. Don't wait. These things take time, whether it's a trust or even just, maybe you only have one heir and a simple will do it for you when you're not worried about probate. It still takes time to get these things done, to especially think through what you want. The more potential heirs you have, the longer it's going to take to think about what your vision is, what are the needs, desires of each of those people. So don't put this off. This is not, there's just been too many examples this year alone of people that I know and people who they've known suddenly not being with us anymore. And that life happens that way. We think we have time, but we don't always. So if you haven't done your estate planning, your legacy planning with your woodland, please start now.
And actually, Mary Sisak is available to provide some one-on-one consult. Mary and Audrey Winograd have been working with us for several years. And Mary and Audrey are both available to provide some one-on-one consult for anyone who is kind of ready, but really doesn't know what to do. So you just need to email me or email Mary. Can I put you in here, Mary?
Oh, good.
Okay.
Yeah. Well, I'm not an attorney, so I couldn't answer your legal questions. But if you're not ready for the attorney, if you're wondering about what could my goals be, or how do I engage the family? How do I know who's interested? What are some of the pros and cons of the different legal structures? How do we communicate this? What about how do we make our wishes known after we're gone? Who makes decisions? Things like questions all like that we've been answering throughout our process or legacy planning webinars. Those are the things that Audrey and I can help you with. We can get you ready to go to the lawyer so that you're really efficient when you're dealing with the lawyer. They know exactly what you're thinking, what you'd like to happen. They can draw up the appropriate legal document for you, whether that's a trust, an LLC, or a will.
So don't hesitate, please, to ask for that one-on-one consult if you need it. That service is, it is funded by Vermont Housing and Conservation Board, Forest Legacy Program. Yeah.
Yep.
Okay.
Yeah, there's a $75 application fee, but after that, there's no cost to you. We can help you up to 2 years.
Yeah. So please take advantage if you need it. And thank you, folks, for being here. Thank you so much, Sarah.
Yes, thank you, Sarah.
I appreciate your expertise. I have a lot of work to do.
Oh, my thanks to the two of you and to everyone for joining in.
Yes.
Good night, everybody.
Good night, folks. Have a good evening.
Night.
Bye.